Hello, everybody. I hope you're all doing well. I decided to hop on and do a video for the most recent response by the court. Judge Gull made a ruling yesterday on the defense's motion to disqualify her as the judge for the Delphi murders. And we've been waiting for this. And I was going to go over the document with everyone. The court has reviewed the defense's second verified motion to disqualify judge and request for findings of fact and conclusions of law. Upon denial of this request, if this court denies this request, filed May 17th, 2024. As Trial Rule 52 is not applicable in criminal cases, the defendant's request for findings of fact and conclusions of law is denied. Neely versus State, 297 NE 2D 847, Indiana Appellate Court, 1973. Davis versus State, 642 NE 2D 987, Indiana Appellate Court, 1994. The court, however, will address each of the defendant's allegation in this order. Defendant claims the court directed the Carroll County Sheriff to ignore a subpoena. The court directed an email to counsel on June 14, 2023, regarding the witness refusing to cooperate with the service of the subpoena and demonstrating a willingness to fight the deputy attempting service. The court requested a report of the witness's refusal to cooperate and be transported for the scheduled hearing, and forwarded that report to counsel when it was received. The decision by the deputy to leave without the witness was his and was not directed by the court. The defendant claims the court engaged in ex parte communication with the Carroll County Sheriff regarding the defendant's housing, transportation, and safety during jury selection and trial May 13th through the 31st of 2024. These communications were administrative in nature and did not address any substantive issues. The communications were directed to where the defendant would be housed during the trial and who would be conducting transportation. The court did not notify counsel where defendant would be housed during the trial, as he is still under the safekeeping order. In an email, but did not inform counsel of the communication, as nothing substantively was discussed. The court has set the defendant's motion to vacate safekeeping order for hearing, but was required to cancel this hearing upon the filing of this pending second verified motion to disqualify. Counsel claimed the court invited the state to limit defendant's Sixth Amendment right to present a defense. The court has always required counsel in all criminal cases to follow the law relating to third-party perpetrators. The court reminded counsel of their obligation to follow the law in the court's email of April 28, 2024. Counsel claim the court has disparaged them and ruled on defense pleadings without hearings. The court's comments about counsel's performance was documented in the court's order of April 30th, 2024, regarding their handling of discovery materials. If pleadings on their face are not supported by the law or admissible evidence, judicial economy does not require a hearing. Allegations the court has treated the prosecution more favorably than the defense are unsupported by any admissible evidence provided by the defense at the March 18th, 2024 hearing. The court was notified on May 20th, 2024 of an inquiry by the Indiana State Police to the court reporter via email on May 9th, 2024 regarding ex parte communication received by the court from Gary Baudet, which was previously provided to all counsel. The court is unaware of the extent of any Indiana State Police investigation. The defendant blames the court for ex parte pleadings which were inadvertently directed to the prosecutor. The defense staff filed pleadings and marked them as confidential, apparently unaware that the confidential marking makes them available to the state, but not the public. Counsel's staff contacted this court staff and were advised that the statewide Odyssey case management system, not DocsPop, as alleged in the pleading, has a distinct process for filing pleadings ex parte as opposed to confidential. The court did email defense counsel a tutorial paper authored by the JTAC explaining the process. Since that communication, defense counsel have had no issues with their staff properly filing ex parte pleadings. Accusations of violating rules on access to court records have been completely explained and dealt with, including by the Indiana Supreme Court in the first writ of mandamus filed by the defendant. Counsel claims their motions are treated differently than motions filed by the state. The court has set hearings on pending motions which have now been continued due to the filing of this motion to disqualify. When the defendant files pleadings, the state is entitled to file a response. The court follows Trial Rule 6 regarding time and gives the state 20 days to respond. Defendant is also given 20 days to reply to the state's responses. Once the issues are closed, if a hearing is required, one will be set. Defendant asserts that the court ignored his request to set aside 2 weeks for the defense case while refusing to set time limits on the prosecution. On March 6, 2024, the defendant filed a motion for speedy trial. The court granted that motion on March 7, 2024, and set the case for speedy trial May 13th through the 31st of 2024. On April 30th, 2024, the defendant filed a motion for a pretrial hearing, which the court set for hearing on May 7th, 2024. At no time prior to the May 7th, 2024 hearing did the defendant advise the court that 3 weeks for trial was inadequate. At no time prior to the May 7th, 2024 hearing did the defendant indicate a belief that 3 additional weeks could be added to the trial without notice to the court, witnesses, and more importantly, without notice to potential jurors. While the court agrees a continuance of the trial is harmful to the defendant and to the state, it could have been avoided had counsel communicated prior to May 7th, 2024. Counsel represents they notified the court on or about October 4th of 2023 that they would need only 2 weeks to present a defense. But the court has no record of that communication, nor any recall of such communication. Counsel's assertion that between all defense counsel with a combined 70 years of experience, not one time have they been told that a trial would absolutely end on a certain day and not go any longer is irrational and unreasonable. The court is aware its colleagues across the state routinely give trial dates that begin on a set date and end on a set date. The court is not required to guarantee equal time for both the defendant and the state. The court is required to guarantee sufficient time on the calendar and sufficient notice to jurors and the parties to present their case however long it takes. Had counsel notified the court within days of receiving the March 7th, 2024 court order setting the case for speedy trial May 13th through the 31st of 2024, that the time allotted on the calendar was insufficient, the court would have immediately rectified the situation and extended the trial to May 13th through June 14th of 2024. Trial is now set for October 14th through November 15th, 2024, as requested by the defendant. Counsel accuses the court of engaging in extrajudicial activity. Counsel is correct that on July 9th, 2023, the court commented on a Facebook post about a softball tournament her granddaughter participated in Delphi. The court did not attend the tournament, but did say congratulations to her former daughter-in-law's post about their team winning the tournament. If counsel's allegations in this part of their motion are well-founded regarding a potential witness' alleged social media activities and are presented to the court for ruling, the court will rule accordingly. Concerns about anticipatory rulings are not reasonable. The defendant asserts the court has denied reasonable requests for funding. This is incorrect. Counsel is well aware of the amount of funds the court has authorized for this defendant. The court has requested the defendant to submit proper invoices and bills for Carroll County taxpayer funding. Invoices which have been submitted without appropriate documentation have been returned. The bill counsel refers to for $26,000 for investigative services from June 4th of 2023 through October 16th of 2023 was in fact returned to counsel as no documentation was provided for services. No documentation was submitted until quite recently. With that proper support and documentation, the court authorized that invoice for payment on May 17th, 2024. The defendant complains that public confidence in this case has eroded. As counsel should know, criminal cases are tried in a court of law, not in the court of public opinion. An independent judiciary requires that judges decide cases according to the law and facts, without regard to public clamor or fear of criticism. The court continues to receive ex parte communications from the public, criticizing the court both personally and professionally, and threatening the court with bodily harm and injury. The court continues to provide these communications to the parties. The court is not interested in memes and other social media content that can be easily located on the internet. Paragraph 129 of the defendant's second verified motion to disqualify. The court cannot be swayed by inappropriate and ridiculous outside influences. The defendant further claims the court has refused to order the state to comply with discovery rules. The court has set defendant's motion to compel and motion for sanctions for hearing, which has been continued due to the filing of this motion to disqualify. The previous defense motion to compel was denied without hearing as it was unsupported by evidence. Defense counsel alleged bias by the court, only allowing cameras in the courtroom on one occasion. The court has not allowed cameras in the Carroll County Circuit Court due to its limited size and layout. The court did allow cameras in the Allen Superior Court at the hearing conducted on October 19, 2023. The hearing was not conducted, and the media outlet provided pool coverage did not comply with the court's directives regarding coverage and broadcasting of the proceedings. The court lost confidence in the ability of the media to cover hearings appropriately. The court has issued adverse rulings against the defendant as well as against the state of Indiana. Adverse rulings do not support a reasonable bias for questioning the court's impartiality, nor are they grounds for disqualification. They are just adverse rulings. The defendant's second verified motion to disqualify judge and request for findings of fact and conclusions of law upon denial of this request, if this court denies this request, is denied. Dated May 31st, 2024, Francis C. Gull, Special Judge, Carroll Circuit Court, Carroll County, Indiana. The notice was given by the court, and the proof of notice under Trial Rule 72. A copy of the notice was sent to Bradley Rosie, attorney for the defendant, Andrew Baldwin, attorney for the defendant, Jennifer Auger, attorney for defendant, prosecuting attorney Nicholas McClelland, deputy prosecuting attorney James Luttrell, and deputy prosecuting attorney Stacy Diener. So there you go, guys. Judge Francis Gull isn't having it. She is not buying what the defense is selling. And she pretty much points it all out. This wasn't a surprise to me at all that she ruled this way. Um, this is exactly what defenses do when they don't have a leg to stand on to defend their client. They're going after the judge. They're going after everything that they can think of because they know that Richard Allen is bridge guy. And that's my opinion in this case by everything that we have seen so far. Um, Sadly, this case could have been already in the court system. A trial would already be going on. And quite frankly, um, we could have had a resolution to all of this and his speedy trial claims had they not sent this ridiculous motion back to the judge. Hang on to your, excuse me, guys. Hang on one second. Hang on to your bootstraps because I guarantee you this isn't the last that we've heard about this situation from this defense team. They continue to add motion after motion. And just because you file a motion doesn't mean it's going to be accepted by the court, doesn't mean that the court is going to rule on in your favor on said motion. They are doing everything that the defense team can do or can think about to try and get the proceedings muddied, stalled. The longer they can keep this out of court, the better for them. As I stated before, witnesses, memories cloud over time, and that's what they're hoping for. Remember, we have eyewitnesses to the defendant being at the bridge that day, and they're hoping that those witnesses' judgment and memories will cloud over the time, the longer this goes on. So we'll just have to wait and see what's next in the case of Richard Allen versus the state of Indiana. Frankly, I believe that this is headed for a jury trial in October. And I really don't see, unless they come up with some sort of new outstanding evidence, I just don't see how they're going to get past this going to trial. Of course, as it has been spoken about previously by many people, there's always the possibility that Richard Allen will want to plea. And that is quite possible. Again, the state has to accept the plea. The court has to accept the plea. It's just not automatic. And those are things that go on behind the scenes. And we wouldn't know anything about any of that until it actually happened. So we'll just have to hang on and wait and see. I hope everyone has the great rest of their Tuesday. And thank you so much for tuning in. Bye, everybody.